Right. Hello everyone, and welcome to our National Training Week session. I'm Adib and I'm delighted to be your host for today's session. We are honored to have our expert trainer, Ms. Carol, who will be sharing valuable insight on fair and effective disciplinary action, best practices for HR leaders. During the session, please feel free to ask questions in the chat box below. Ms. Carol will address all questions at the end of the session. As a reminder, please keep your microphones muted throughout the session to avoid any disruptions. Without further ado, I hand over the floor to Ms. Carol. Ms. Carol.
Good afternoon, everyone. Welcome to our session today in the 9th of August, 2 p.m. So our session will run for 2 hours. So how are you all today? Good afternoon. Yes, I see the messages coming in. There are more to come in. I think let them come in first. We can start since it's already 2 p.m. Right, let me put up the screen. Okay. If you all can see the screen, you can put a thumbs up. Yes. Okay, good. I am good. Thank you for asking. Okay, thumbs up is there. Right. So y'all can hear me clearly. If in any way you can't see the screen or can't hear me in between from now to 4 o'clock, to let me know, yeah? To raise your hand and put up your message in the chat. Okay? So today we are going to talk about fair and effective disciplinary actions, best practices for HR leaders, right? So I'm Carol Anthony. Just a little bit about myself before we move on. Okay, all right. So I'm a corporate trainer. I do a lot of training. Most of them are related to HR and some are management as well. So I've been doing this for the past 7 to 8 years. All right. So before that, I was working in several different corporate companies, multinational and also local companies, all in Malaysia. And I was in HR department for 20 odd years, right? My last position was as a HR manager at a logistics company where I worked there for about 9 years. Then I left to become a corporate trainer, and I also, on the side, I also do HR consultation for SMEs, those who don't really have a HR person, and performance coaching as well, for those who want to increase their performance in an organization, right? So my qualifications, you can see one of it is on HR management. So those days is called personnel management. So I got a certificate on that. And of course, on training and assessment and business administration would be my degree. And my master's is on entrepreneurship. That is why I'm now an entrepreneur, right? So that's very basic information about me. If you want to know more later, you can ask me, right? And in between, I will share my experiences as well. So what are we going to listen to today? So these are the contents. First, we'll define what is disciplinary action. We'll talk about legal and ethical considerations, role of HR in disciplinary actions, and then consistency and fairness, employee training, and also we'll analyze some of the real world scenarios or case studies. Yeah, we'll look at some cases and then see what went wrong, what could have been done right, and so on, so that we can learn from it, right? So since today is only 2-hour session, so I'm going to give you some of the pertinent or important information when it comes to taking disciplinary action. But some of it could be detailed, some of it is not detailed because it's only 2 hours. Usually this training I conduct is either full day or 2 full days, meaning it's 9 to 5. All right. Then only we can cover a lot of areas because disciplinary matters are big part of an organization as a whole and for HR as well. Right. So here is only the main important points which will also benefit you. Okay, if you're new or even your old HR, it will be a refresher course for you as well. Right. So I have a few sections, like you saw the contents, there'll be 6 topics. So after each topic, you can put in your chat in the questions. You have any clarifications. Otherwise, you can wait until the end of the session and then post your questions. All right. Okay, so first one, defining disciplinary action. So what does it mean to be fair and effective? Our topic says must be fair and effective. So usually we don't talk about fair when it comes to disciplinary action. Usually I've seen a lot of companies or HR, they will say, oh, he's done wrong or she has committed a misconduct. So we're going to take action against her. We don't care about fair or what. Some companies, some are fair, of course. So here we're going to talk about why we need to be fair, all right? Because we want to address the problem and then make sure that the problem doesn't repeat. Okay, if you're not being fair to the employee, then they may feel victimized and then they can take other actions. And then overall, it's not good for the company as well, right? And the second part, of course, we want to be effective. So once you take some disciplinary actions, there has to be some good, positive consequences. So we'll talk about negative and positive consequences later. So if it's not really effective, I would say it will produce negative consequences in the organization. So if it is effective, positive. Okay, we'll talk about it later. Okay, so what are the purposes and objectives of disciplinary action? Of course, we want to correct the behavior, improve the performance issue if there are performance issues, and we don't want them to violate our company's established rules, policies, and whatever standard procedures that you may have. All right. So as you can see, the point forms below here, correct behavior, maintain order, of course, because everyone violates the rules, there's no order. Okay. Promote accountability. We want the employee to be accountable for whatever they have done. Accountable means admit, okay, it's their mistake so that they don't do it again, right? Next, we want to protect organization integrity. So as a whole, if there are disciplined employees, the organization also can be perceived as having integrity, right? Prevent recurrence, of course. We don't want others to follow suit. If we don't take action, example, someone walks in late 15 minutes to work, you say, never mind. Then next day, there'll be 2 or 3 persons walking in late. Okay, so we want to prevent recurrence and encourage improvement, right? So overall, disciplinary actions are intended to support for a positive, productive environment. Okay, this is just a brief overview why we do disciplinary actions. Yeah, not I mean the main part is one. If you notice, I didn't put punish. Yeah, some will think it's we are going to punish the employee. So I would term it in a positive way. That's why I put all these things. Okay, correct behavior, maintain order, and so on, and not punishing the employees. So I wouldn't see it as punishing, right? Okay, next. Okay, so before we take disciplinary action, we need to know what are the misconduct. Okay, it can be all of this and more. So I've just put in a few here. Theft, malingering, fraud, non-compliance to your policies, tardiness, misuse of company resources, violent and abusive behavior, fighting in the premises, hitting another employee, discrimination of any sort, harassment, including sexual harassment, safety violations, okay? Some safety protocols you put in place, they violate that, right? Violation of confidentiality, some confidential information you're not supposed to share with someone or outside the company, they went and shared, right? Breach of code of conduct, whatever code of conduct your company may have, and then conflict of interest. Conflict of interest would be, let's say they are working for you as a salesperson, then they also go and work part-time as a salesperson in your competitor's company. All right. So that would be conflict of interest. Right. Fraud, I think you all know what is fraud, meaning portraying themselves as something else, and then maybe to the client or to the vendor, they portray themselves something else too, for the purpose of fraud. Fraud could be to get money from them or to get some favors, right? Okay, so I have few questions for you when it comes to misconduct. Okay, I have questions for you. So it's good if you all can take part. So we make it a little bit interactive. So I want you all to put in your chats, okay, what to put in here, all right? Categories of misconduct. So in organizations that I work and also where I do consultation, this is what I do. I tell them, you need to categorize your misconduct, okay, according to minor, major, and then one more I just add is insignificant. Why insignificant? It could be something that, you don't need to take action, but it's still a misconduct. Okay, then maybe you say it's not so minor or major, it's doesn't cause a big problem. So now we don't take action. That's what it means by insignificant. So there's minor and major. Why we separate it? Because later we're going to talk about disciplinary action. It has to be different for minor and major. Cannot be the same. That's what one more thing we're talking about, being fair, right? So we cannot say, oh, minor, there's someone who walked in to the office late, 30 minutes late. That could be minor, yeah? So major could be someone stole the office stationaries. Okay? Big amount of one box of stationaries missing from the office, right? So minor could be coming to work late, one time, 30 minutes. Major could be stealing. So the punishment, disciplinary action should be different, right? So that is why it's good to separate. And this is what I used to do in my previous company when I do a policy. Okay? When there's a HR policy, I will clearly put it down there. What are the minor misconduct and what are the major misconduct? So the employees are aware, okay, minor, these are the disciplinary action they will do. Major, these are the things. All right? So I want you to take few minutes, maybe 3-4 minutes. Put it in the chat for me. What you think is minor, what you think major? Misconduct. And maybe what you think is insignificant. It could be based on your own experience or your own company practice. Okay, let's take about 3 minutes to do so. I have a few samples later I will share, but I want input from you first. If you give your input, it's also, it's good for discussion and for all the participants also, they are aware, okay, what is happening in other companies as well. But what do you term as minor misconduct? What is major? Okay, someone says major, taking alcohol during office hour. Okay, good. Minor will be late, right? Late for work. simply throwing rubbish. Okay, good. Minor. Major, of course, stealing. Major is theft. Yeah, habitual lateness can be major as well. Minor could be lateness maybe once or twice a month. Okay, good. Fraud is major. Okay, good. Falsifying MC, yes, it is major. Uh, somebody's somebody is unmuted. Can you mute yourself? Mm, Fazila, I think. Can you mute yourself? Okay, major no-show, rudeness with no tolerance at all, offending, misconduct, violation against PDPA, policies, company stock, company's items, yeah, good. Late, minor would be late, rude, okay. Minor, late again, MIA, missing in action, major, fight and theft, insignificant could be dress code, all right. Major is insubordination, consuming illegal drug, major harassment or discrimination, embezzlement, of course. Okay, all right. 1 more minute. Anyone else have any input? Okay, thinking the company's client as our own clients, major, okay. All right. Coaching, yeah. Insignificant could be personal phone calls or text during work. All right. Endanger life and safety of others could be major safety issues, yeah. Improper dress code could be minor, okay. Some say insignificant. Okay, this one is improper. It's become minor. Right. So I hope you all get the message what is minor and major. I hope you all in your policies or procedures do have this distinction, yeah. For your own purpose, when as you as a HR want to take action, it's easier as well. And then for employees to know also, right? Handling companies confidential major. Okay, good. So if you don't have, please do so. You may have lumped all together. Now you can separate them between minor and major. So let's see what I have here. Some of it you've already mentioned. Okay, some of it may be different. Let's see here. Okay, so minor, I put there tardiness, coming to work late, less than 3 times a month, example. Okay, if more than four or more times, then I would consider it as major. So it differs from company to company. Yeah, this is just an example. Number 2, leaving office early. Again, not only coming to work late, leaving early. Number 3, not completing a task less than 3 times. So similar to insubordination. Yeah. 4, shouting at a colleague in the office. 5, taking office stationery home. Pencil, pen. Okay, why this can be considered stealing, yeah, but why do I put as minor and not major? Anyone knows why? Number 5, taking office stationery home, pencil and pen. Okay, why I put minor is because some people, they actually, okay, no big impact to company, all right. No big impact is fine. What I notice is some people accidentally take it back. It's not intentional. Why I know this? Because I've done that. Okay. Sometimes I come back. I even have gone to my colleagues' desk, talk to them, and then I'll come back to my desk with their pen. Okay, it's not stealing, it's unintentionally. Okay, because it's small things. So that could happen. That's why I put there minor, right? 6, adhere to company dress code, uniform. Number 7, absence for less than 2 days. 8, taking long lunch break. Okay, I've seen this many times in my previous company. Why it happens? Because we give flexi lunchtime. Some can go 12 to 1, some can go 1 to 2, right? So what some do is they go out 12, they come back about 1:30 or 2 o'clock. Extended lunch break. 9, malingering. 10, loitering, right? Then we come to major. Fighting with another colleague, violence, right? Stealing company property. Stealing would be more valuable items. Absence from work without leave. Insubordination of any kind. Sexual harassment. Malingering again. So malingering, you can put number of times, yeah, or how many hours they malinger. Malinger means they are doing work slowly or not at their workplace. Damaging company property, 7. 8, using company property vehicle without permission. 9, drinking alcohol, getting intoxicated. 10, giving false information to anyone or clients. Okay. 11, forging signatures is very serious. 12, divulging confidential information to a third party. 13, tardiness, here I put there, coming to work late more than 3 times, right? And leaving office early also. The last one you can see is leaving office early more than 3 times. And then insignificant, again, I said it depends on your company. So here I put there dress code, coming to work late maybe once in a month, leaving office early maybe once in a month. Yeah. So it differs from company to company and what type of industry you're in. So let's say you are in a production industry where everyone has to start work at 8. If one person is missing and then the production line cannot move, then it's serious. Then even coming to work late once would be a major misconduct because then you won't meet the production deadline. Maybe clients then won't want to use you anymore or buy from the company anymore, right? So again, it's different from industry to industry. Same with, let's say you hire a security guard. So he's stationed at the guardhouse, example, from 12 hours. And then part of the hours he's sleeping. Compare that to a clerk who's working in the office, working also 8 hours. And then part of the hours, the clerk is sleeping. So which is more serious offense? Sleeping on the job, of course, serious, but more serious would be for the security guard. Why? Because if he's not guarding the company, the premises, someone could enter in and steal your products. But if the clerk is just sleeping on the job, nobody can steal anything. Only thing, her work will be delayed. Yeah, so you see the seriousness of the misconduct will depend on the job scope as well. Industry, job scope. Okay, so based on that, you can play around which one you want to put minor, major. Insignificant, of course, is for your own record. No need to put in the policy. Otherwise, all will start doing this. We don't want to let them know it's insignificant. It's just for HR record. Okay, right. Let's move on, next one. Okay. So now we know what are the misconduct. There are so many types, and then we segregated them. So it's time for us to take disciplinary action. So disciplinary action for me, it will be two types. One is preventive, another one is corrective. Okay, so preventive will come to you later on. So we'll zoom in on corrective today. So preventive, I'll just give an overview later. We can't cover that today. So we'll focus on corrective. Okay, so what are the types of disciplinary action? So these are few that we can take action. First one, you see verbal reminder. We'll go in details, some of it later. So this is just an overview for you. Verbal reminder, verbal warning, reminder, warning. What's the difference? Later we'll go into that. Show cause, domestic inquiry, suspension, demotion, counseling, PIP, or short is a acronym for Performance Improvement Plan. Then next, freezing of promotion, transfer, increment, bonus for a specified period of time, termination, report to the authorities. Okay, report to authorities will come in when there's criminal cases. Yeah, then you have to report to either police or maybe anti-corruption agency if there's a bribery or corruption happening, right? Other than that, then you follow the rest of this company can carry out on their own. Okay, so verbal reminders and written. Why is that different? Why I put it separately? So what I used to do in my organization, it has worked. Okay, so before that, whatever I'm sharing with you is based on what has worked when I used to work in a few different organizations. Yeah, why I say it's worked? It has ensured that the company is working. The employees are working in a good environment and most of the time disciplined. Okay, so the disciplinary actions that are carried out have ensured that. Okay, so why I would safely say that? Because when I was the HR in few companies, none of the employees went to the industrial court. Okay, that's the worst part of for any organization when the employee sues someone in the court. Okay, because it takes time and then it takes a lot of money to hire a lawyer, and then if you lose the case, then you have to pay compensation for the employee as well. So I can really say that whenever I do all this, that's why I'm sharing in my trainings. Whenever I do all this, it's full proof that the employee got no way to go to the industrial court. Okay, they have tried. They have gone to labor department. I've gone there. The case got thrown out. They have gone to the industrial relations department. The case got thrown out because I do everything foolproof. That there's no way that they can find fault with the company. All right. So that's why I'm sharing all this. Hopefully you all can implement and then do the same so that you take care of your company as well. Take care of the employee at the same time. Yeah. Okay. So come back to this verbal and written reminders. So first, what I'll do is, if it's a minor misconduct, remember minor, then we can give a verbal warning or verbal reminder. So verbal reminder means just call them in for a while, have a talk with them, maybe 20 minutes, 30 minutes, say that you have done this. It's violating what clauses in our policy, and then next time, please don't do it. So this is a reminder for you. So it could be reminder if it's 1 time, 2 times, or it could be verbal reminder one time, 2 times. Okay. So why verbal? Because we don't want to make it official, black and white. Because when we make it black and white, it need to affect their performance review by the end of the year, and it may affect their increment, bonus, etc. So for that purpose, what I'll do is give them verbal reminder and warning first. And even if it's verbal, I will record it. Okay. So most companies, they don't do this. So verbal also record it. Okay. Record meaning is not letter given to them, but it's like a form. I created a form, have a verbal reminder form or verbal warning. I'll say, okay, I've seen the employee from what time to what time, who was present in the meeting, could be HR, supervisor, and the person who violated whatever clause. And then what did we discuss and what was agreed by the employee, right? And then no need to give them to sign. You just HR need to sign and put it in their personal file. So you also have a record to show that, okay, what you have done, you've given them verbal warning or verbal reminders. Okay, a lot of times this is not done. Even if it's done by the immediate supervisor or manager, it's good to have a form, fill out, put it in. This will save you a lot of trouble if the employee goes to the labor department or IR department. Then comes to return as well. Of course, return, you want to enforce it and make it more serious. As I said, it may affect their performance review at the end of the year, right? So who is involved? Involved parties could be witnesses, supervisors, who knows about the problem. You see the slides here. What could be, you write about the nature of incident, what are the impacts, all right? And what was done and by whom. Quote the clause in the policy or handbook. Remember I said have a policy with minor, major misconduct. So now you need to quote the policy. Otherwise, employee don't know. You never tell me. You never wrote anywhere. How come you give me warning? Okay, you know what? You know it's not good to do that. That's not acceptable. Huh? Some company will say, you know what? This one cannot do. I know, but where's the black and white? So put it in the policy or handbook. Where location of incident, put it down, and when, date, and time of incident, events before or after, whatever happened before or after, also, if it's relevant, state it. Okay? State it in the verbal or verbal reminder or warning in the form, also state it. If it's going to be written letter given to the employee, also state all this. So that why? It's all clear. Everything is encompassing. Okay, don't miss out any details. So my warning letters normally I used to issue are very detailed. Not long. Okay, it's not too long so that employee get confused, but it's to the point and all these are covered. Okay. You make it too long also they don't understand what you're talking about. So you have to get to the point, right? Okay, next we come to show cause letter. So show cause letter we issue when? When do we issue? When we are not clear of what happened, what really happened. So sometimes you have issued, you have called in the employee to ask them, hey, what happened, but it's not clear. And maybe the witness says something else, the supervisor says something else, so it's not clear. All right. So you can't straight away give them a reminder or warning, right? You need to do your own investigation. And during investigation also issue show cause letter, right? Okay, 𝐂𝐸𝐬𝐬𝐷, you're asking for the example, eh? You mean the previous slide, is it? You want to see? Right, just a minute. Okay. All right. Later, I'll go through this slide first. Later, I'll go to the previous slide. Okay, so show cause, who is involved? Again, involved parties, witnesses, supervisors. What you quote the nature of incident, what are the impacts, what was specifically was done by and who. Quote the clause again, location, date, and time, same thing, yeah? And then reply. This one, you need to give them a specific date and time in writing. Okay, ask them to write and reply. Schedule a meeting to respond to the reply verbally. Okay, and then take action. So specific date and time, I would suggest give 3 working days. Usually I just give 3. Too long, they also forgotten what it was all about. Sometimes they don't even reply. I've I've come across a lot of cases. So I just give them 3 working days. Within that, reply. And some of them, they don't know how to write. I've encountered these cases. So what do? You can schedule a meeting and ask them to reply verbally. Then you just record down and then get them to sign. Okay, this is your reply. Either you say you are guilty or not guilty, right? These 2 things. Either they admit or they don't admit. Okay, so if admit clear, then you go on to the next step would be give them a warning letter or reminder letter, right? If they deny, they say they are not guilty, they didn't do it, then you need to go to next step, which you all know. If it's not clear, you need to do a domestic inquiry. Okay, so that is a long process you need to do. Right. So let's see the previous. This one, I think 𝐂𝐨𝐬𝐬𝐷𝐿 wanted to see this. I believe later they'll let you know. I think maybe the slides will be available. I'm not too sure. Later, Excel Academy will let you know, right? Okay, there's a question. Let me see whether I can answer the questions first. Manjit would like to check if your 1K staff was not given JD, but issued show cause letter for not completing some task. Okay. All right. JD usually is very general in nature, right? What need to be done for the job. But if the supervisor or manager gives them a task, I'm sure the task was explained to them what to do, right? And if he didn't do, then it's good to issue show cause letter and ask him why he didn't do it. Can. Not necessary to have a JD, but the information should have been there to tell them, okay, this is the task. You need to do this, 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 this. But ideally, of course, all employees need to have a JD. But JD is very general, actually. So the day-to-day task will be more detailed, right? So you can issue show cause letter to answer Manjit. Okay? All right. So let's go on the next show cause. Then we come to domestic inquiry. So remember the next step, usually you issue show cause letter first, then only jump into domestic inquiry. Before that, ideally don't jump into domestic inquiry because we want to be fair. Remember I said fair and effective disciplinary action. So in this case, fair means you're given the chance for the employee to answer first, just the show cause letter first. So if their answer is unsatisfactory or you still think they are guilty, then again, this is domestic inquiry work both ways. It's also being fair to the employee as well. Meaning you're giving them the opportunity to explain further to an independent people because you need to have 3 persons as a panel to hear out the employee side and the management or HR side of the story. That's what domestic inquiry is all about, right? So you give them, again, a fair chance. You say, oh, no, your supervisor, HR not victimizing you. Now we have 3 independent people going to listen to you. All right? So here you see section 14.1. Of course, we need to refer to the Act. So here is Employment Act 1955. It says that before we dismiss someone, okay, an employer may, on the ground of misconduct inconsistent with the fulfillment of the express implied, after inquiry, dismiss without notice the employee, downgrade the employee, impose any other lesser punishment, including suspension for about 2 weeks without wages, right? So domestic inquiry is not solely to terminate employee. So think about it as giving a fair chance for the to listen to the employee side. And of course, after that, your decision would be can terminate Or you can downgrade. Maybe now they are executive, later you downgrade them to officer level, example. Or you give them just 2 weeks, no wages, suspend. Don't come to work, you don't get paid. All right. These are the things given by the Employment Act that you can do. Without domestic inquiry, don't do all these 3 things. That's what it means here, Section 14. These 3 things don't do without domestic inquiry. So a warning, other things, not this, right? So typically organizations encourage to conduct DI for the following reasons: to show that an employer is keen to ascertain the truth and is fair, right? Employer to prove the charges of misconduct and give employee sufficient opportunity to defend himself. Okay. And when the case referred to industrial court, there's a possibility that witnesses may no longer be with the company or their memory may have been lost, faded. Okay. So that's why domestic inquiry is important, because you have all the notes recorded and then there is evidence there to show if the matter goes to industrial court. Okay. So I have gone for cases in industrial court. Just now I said when I was HR, employee didn't go to court, right? But when I was in the company, previous cases were there that I needed to handle because I was in charge of IR as well. Okay, so I needed to handle, so I've been to court in KL, Johor as well. All right, and this has happened. After many years, the case came up in court, and then the witness is one of our ex-staff who has already resigned. Then I needed to go and call her to come to court to give a statement, witness statement. So it's been like 3 years ago, you know, and then she also can't remember but came, and then we are not supposed to compensate her with anything. Yeah, that would be construed as bribing her to be on our side. So when she come also, we cannot compensate her for transportation, for taking leave from a company also, we can't do that. Yeah, that was a big problem. So we just need to ask her for a favor, that's all. Cannot do anything in return. Okay? Because if the court knows about it, then they will say you are, you know, bribing the witness to give false evidence, right? So that's what happened. I need to go and see her, you know, some more this was in Johor. Okay, so I had to fly all the way. I was in KL, go and see her in Johor and make sure that she comes to the Johor Industrial Court. Okay, there's some comments here. Let me just read the comments. Wong says, sometimes it's unfair due to massive headcount in charge and ad hoc tasks overloaded. What do you mean by unfair? Unfair for HR to do DI, is it? That's what you mean? Okay, think that's what you mean. But as a HR, as I said, this is the job. Okay. Why? Why is the job? Because Employment Act says so. Employment Act is like our, you know, go-to book. We have to follow whatever it says. If it says this, we must do it. That's why we are HR therefore, right? Okay. So if it's a lot of work to do, you can't handle, then it's up to you to talk to your boss about it, right? Okay. Another question is, example, one person in charge of headcount alone, 3.7K. 3,700 people, one HR is impossible to handle. Okay. So you have to speak to your boss clearly to tell them, this is impossible. There are things that I cannot do. And if I don't do, we are violating the Employment Act 1955. And if we violate, these are the consequences. Tell them. I know some employer will ignore. So what I would advise is for cases like this, put it in black and white. if you still want to work there, okay, send an email to your boss to say that, okay, this case has happened. This one we have to do domestic inquiry, but I alone unable to do it. I need few more people to do it. Why we need to do it? Because of the Section 14 in Employment Act says so. If we don't do it, what are the consequences? Also tell him. Consequences, the employee, if he goes to the industrial court, file a case, then you have to hire a lawyer. Then if the employee wins, you have to pay compensation up to 24 months of their salary. Okay, so help them wake up. Sometimes the bosses do know about this. So we as HR, you have to tell them why I say put in black and white to safeguard yourself. Because later on something happened, they will say you didn't tell me. So now you have black and white email to the boss to say that I told you so. Otherwise, you will be penalized. Say, hey, why you didn't take care of this matter? Right? Okay, do that. Next question, Ng is asking difference between due inquiry and domestic inquiry. In the Employment Act 1955 or even Industrial Relations Act 1967, due inquiry is not mentioned. Okay, they only talk about domestic inquiry. So sometimes I know HR will use these two terms. They will try to differentiate, talk about it. It's up to the company, but the Act only mentioned domestic inquiry. So due inquiry could mean that you are just having a chat with the employee on your own, one-to-one, or with the supervisor, that's it. Some HR translate it that way, but it's not in the Act, okay? So I'm quoting the Act is only domestic inquiry, okay? Hope I answered that question. Right. Let's move on to the next one. Okay, in DI or domestic inquiry, the principles of natural justice are absent, would declare such inquiry to be defective inquiry. Okay, what does natural justice mean? Meaning you're giving a fair chance again to the employee to defend himself and then giving all the information to them. Later, there's one case, we'll talk more about this when we talk about the case. Next, termination. Based on the employment laws, company may terminate the employment, okay, with these two acceptable reasons are considered lawful and fair due to an act of misconduct. First, second, job redundancy and retrenchment. These are the only two things that employer can terminate an employee, all right? And the burden falls on the company to justify any termination. Okay, that's why we are having the domestic inquiry also, to justify why you are going to terminate the employee. Okay, every employee has certain express or implied obligations towards his employer. Okay, so anything that violates that, of course, you can take action. So whatever is stated usually in the contract of service, which is an appointment letter or offer letter given to the employee, right? Usually terms and conditions stated there, or in addition, it can be read together with the policies or handbook. Then whichever they violate, then you can take action against the employee. So one more thing is whenever I do a letter to the employee, I will state there, for further information, refer to the employee handbook, because I used to have an employee handbook. Then in the employee handbook, I will put there, whichever is not stated here, we shall follow the relevant acts, such as Employment Act, Industrial Relations Act, Trade Unions Act, and so on. I don't name all the acts because there's so many for employee, right? So I'll just put whatever is not stated here or not mentioned, no details, refer to the act. Again, all this is to safeguard the employer as HR we take care of both sides, right? But of course, first we think of employer first. Why? Because they are paying you. Second, then you take care of the employees. So first, safeguard the employer, then employee rights. Of course, later on you can ask for their rights, don't be too harsh on them and so on. Okay. Right, next one. So termination, these are clauses from Employment Act, and the last one is from Industrial Relation Act. I hope you all are aware of all these acts. Okay, you need to know. So because today we are only talking about misconduct, there are so many others in the act which you all need to know, yeah? So section 14 states that due to misconduct, you can dismiss the employee or terminate. 14.2 says you can suspend the employee for a period not exceeding 2 weeks, right? For the purpose of holding an inquiry. This is before domestic inquiry. Okay, so before domestic inquiry, you can say, hey, we want you to stay at home, okay, because maybe the misconduct is too severe. Maybe he stole something for the company, or he may have access to some information which you don't want him to get access. So you say we suspend you, but with half wages. So once inquiry is over, he's found not guilty, then you pay him back his wages. But if you're going to suspend him after the inquiry found guilty, then of course this one you don't need to pay back. Okay, so this is half his wages. After that, you need to pay it back if he's found not guilty and still working with you. Section 20, this one is for the employee to lodge a report at the industrial court. They have 60 days to do so, the employee. 60 days from the date of termination. Then they can say, go to industrial department first, industrial relations department, to lodge a complaint, right? So usually I have done these few terminations. So we'll still keep the employee's file for 60 days. Okay, we won't consider terminate yet because we want to see whether he goes to court or not. Okay, as I said, as long as I was there, nobody went lah. Right. Okay, so termination process, typical process flow. So first misconduct, then you issue show cause letter, then you receive a reply to show cause letter, right? For major misconduct cases or special case, you can suspend them. It's optional, as I said. And then if reply to show cause they admit, then you can mete out the punishment or any letters to them. Okay. Or if you're not, if they are repeated offense or habitual offense, then you go to suspend them and domestic inquiry. Okay. So domestic inquiry, after that, what happens? After domestic inquiry, just now we talked about it. I put in few here. You can demote them, terminate, or you say they are not guilty, or could be guilty and remain in current position, but given a stern warning, also can. Okay. Guilty and no pay during suspension, or other actions determined by the company that are permissible by law. Okay, just now I gave like freezing. You can freeze the bonus, increment, transfer, promotion, or none. Also can. Okay, there's a question by Ong. I would like to ask if the employee found guilty after DI, company not required to pay 2 weeks suspension period. Am I right? 2 weeks suspension. If you're going to give that suspension, then no need to pay. Okay, but if you're going to give other like this one, guilty and remain in current position, but just give warning, then you give back the suspension money. Unless you want to put it as part of the punishment, then no need to give back. Yeah, it depends on the company. You want to give or don't give. Right? Clear? Okay. Right. Let's go to the next one. Okay. So now we go to legal and ethical consideration. Next part. Any more questions so far? Any more? Let's just give, before we go on, give about 2 minutes. For any more questions, you can put it in the chat. Okay, no more. Let's go on then. No more questions, but keep it coming. Later, I'll have a look at it. All right. Okay. So, employment law and regulations. Of course, as I mentioned, you all need to know. The major ones are these. For those who are in Sabah and Sarawak, there's a different one, yeah. There are slightly different clauses. Employment Act 1955 is only for Peninsular Malaysia. Okay. Sabah has Sabah Labour Ordinance. I'm missing. And Sarawak has Sarawak Labour Ordinance. Okay. So here, most of it, I quote Employment Act and Industrial Relation Act. I didn't quote Sabah and Sarawak. So for those, if you are in Sabah, Sarawak, just take note of that, and then you need to refer to your ordinance. Okay. So Employment Act, of course, as you all know, currently it has been expanded to all employees. Yeah. So previously, it's only first time, it was only 2,000 and below. Those who earn 2,000 wages and below only covered by Employment Act. Okay. So now it's been expanded. No matter what is the salary, as long as they are considered employee and given a contract of service, they are covered under the Employment Act. Only variations is for OT purpose and retrenchment benefits. Yeah, 4,000 ringgit wages and below can get overtime, rest day overtime, and also retrenchment benefit. That's the only difference. Okay, 4,001 and above, they can't enjoy overtime. Next, Industrial Relations Act. Basically, this is for two purposes. One is termination of course for dismissal cases. Next is for union cases. Union, if they want to have what they call a collective agreement or conciliation, then they'll refer the matter to Industrial Relations Court. All right. And the next one is Trade Unions Act. For those who have union in the company, then you have to follow this act to the T, right? Oops, I jumped. Is there a question? Okay, there is a question. If HQ is located at Peninsula, but we have office at Sarawak, should be covered under EA or Sarawak. Okay. The location of the employee, you have to follow the location of employee, not the HQ. If they are located in Sabah, follow Sabah. Located in Sarawak, follow Sarawak. Yeah, so it's not as per HQ. Even like holidays, right? Let's say we have different states, different holidays, correct? Even the working days like Johor, they work on Sundays. Okay? Friday, Saturday is their holiday or rest day. And then Sundays they work. So you have to follow according to the state. Okay? All right, next one. Other acts could be so many. Yeah? I've just listed down some of it, which is related to employees. Okay? Workers' Minimum Standard of Housing and Amenities Act, if you're giving accommodation or hostel to local or foreign workers. Minimum Retirement Age Act, Employment Insurance System Act, EIS, Children and Young Persons Act if you're employing minors, Employment Restriction Act, Occupational Safety and Health Act for safety violations. You need to refer to this. Yeah, misconduct involving safety. Minimum Wages Order, National Wages Council Act, Factory and Machinery Act has been repealed, no longer available. Okay. Employment Information Act, Personal Data Protection Act. Then regulations, orders, there's employment termination and layoff benefits regulations, giving more information about retrenchment. This is retrenchment. Code of Conduct for Industrial Harmony, and there's also for part-time employee regulations. So when you hire employee for part-time purpose, you need to follow these regulations because some of it is not in the Employment Act. You have to refer here. Okay. So beyond the organization, that is all within the organization, you refer to all those. If cannot be handled, of course, it goes external, which is Labor Department usually disputes, okay, some disagreements or dissatisfaction among employee, they can go to Labor Department. And IR, as I mentioned, is for termination cases which will be referred to Industrial Court. And Industrial Court may do any one of these. First, it could be mediation. Okay, before even going to the court itself, mediation usually done in the judge's chamber. Okay, I've attended few mediations before. It will be in the judge's office only, right? Then conciliation hearing. Right, conciliation will be in an office as well. If cannot be conciliated, then go to hearing is in the court. Then award will be given by the Industrial Court. Then there's an appeal process. The employee or employer can appeal, and then you get a legal representation. Lawyer lah, you have to hire a lawyer to represent you. Employee who wants to get representation, if they don't have, usually they don't have much money, okay? So they can go to MTUC, okay, Malaysian Trade Union Congress, and get a legal representation for free, okay? This is what one of our employee that was constructively dismissed in my previous organization by my then HR director. Okay, she constructively dismissed a HR clerk. Then he went to MTUC. Although our company, we didn't have a union, he still got representation from MTUC for free. Then he won the case. Okay. Right. So this is the Industrial Court typical process flow. So there are 22 industrial relations court in Malaysia. There are 16 in KL, 1 Johor, 2 Penang, Perak, Sabah, and Sarawak, 1 each. Okay, and this is the process flow. Okay, this diagram I got it from Industrial Court itself. It's their diagram. So I just put it in here for clearer information. Okay, so first, receive case referred by minister or direct reference to the court by anyone, okay, by the company or the IR department. They register the case. Then they serve notice for mention. First one is called mention, right? Before the hearing itself, they want to mention what is the case all about. So you have to, company and the employee have to attend the mention, right? Then we go to hearing, fix the hearing date. If mention cannot settle, and they go to hearing, then settlement, then last is award. Okay. Okay. So now we talk about ethical principles in discipline. So when disciplining an employee, ethical principles are crucial to ensure that the process is fair, respectful, and constructive as well. Okay. So here are some key principles: fairness, transparency, This is what I mean by transparency is the policy, yeah? Must be clear. This is a misconduct. And then what we will do, what are the consequences of the misconduct, what we will do, issue termination, issue reminder, issue verbal reminder, all this is what I call transparency. Otherwise, it's ambiguous, it's not clearly stated, then you simply blame the employee. Oh, employee didn't do, Okay. Due process, follow the processes that we have, like issue reminder first, warning, give them some chance, like verbal reminder first, then only give written reminder, respect and dignity. So no need to call the employee and then shout at them. Example, yeah, no respect, or accuse them in front of other people or other colleagues. Yeah, instead you should bring them into a room and talk to them professionally, even though they have done the misconduct that you know for sure. Okay, like I've caught some employees with fake medical certificates. All right, so I know it's fake. I've already checked it. We've already written to the clinic to verify. Then I still call the employee in, talk respectfully to them, and then we say, okay, we are going to do a domestic inquiry, and then you need to be present at that time. But of course, since this is a major misconduct, we will need to report to the police as well. Okay, still talk very nicely. And then after a few minutes, the employee said, I want to resign. Okay, of course, that is good for HR lah. You don't have to go through all the process of domestic inquiry. Okay, they realize they are going to be terminated anyway. Okay, all right. So respect and dignity, proportionality, meaning minor misconduct, minor discipline. Just a letter will do. Okay, proportionate to the misconduct. Confidentiality, make sure that nobody else is informed of that. Okay, just between you and the employee. Employee want to tell, it's their problem. But you as a HR or management, we keep it confidential. Documentation, very important. Whatever meetings that you have with the employee, document it. Okay, right to appeal, give them a right to appeal as well. Like domestic inquiry, once you've done, there's an appeal process. To the top man of the company, they can still appeal. Please don't give me this termination or suspension, they can still appeal. So you still need to give them this leeway. Compliance, make sure you comply with whatever is stated in the policy, and being human. All right, so HR sometimes, some companies, not all, forget that, we are dealing with humans. It's not a machine, it's not processes, it's human. So we need to sometimes weigh in. That's why I said, sometimes you say it's insignificant. Don't always jump into taking disciplinary action. All right? Okay. This is the one just now I mentioned, consequences. Remember the first slide when we started? I say when you take corrective action, there is positive and negative consequences. So most of the time, if you follow all this, most of it, if you follow all this, most likely you get a positive consequences out of the corrective action. All right. So you can see improved behavior in that because you treated them with respect, give them time to appeal, hear them out. Then you say, oh, the company is really concerned about me, they are respecting me, then their behavior may improve. Then you'll see increased productivity as well because they feel appreciated even they did wrong. Company was not too harsh with them. Improve organization culture. Culture as a whole also will be improved because you're respecting each other, right? And then good environment to work in. So it will be a good environment overall, okay? So these are the positive aspects. Then you see on the left-hand side are negative. Negative usually because sometimes the supervisor or manager or HR is also, the face also so garang, not friendly. Yeah, very angry with the employee, show at the anger, and then the employee also feel they have a grievance. Okay, they are not happy to work there. Then they may resign also. Sometimes you want the employee. It's not that you don't want them, but they did some misconduct. But due to the action taken not conducive, then they may resign. And the next one, of course, they may file a complaint. Okay, they can complain even though they are not terminated, they can complain at the labor department. I'm unfairly treated, they did this, they did that, right? And then lastly, creation of toxic environment. If they still stay on, they will be talking bad about HR, talking bad about the manager, supervisor, then everyone else got influence, become toxic. The environment become toxic. Yeah. So that's why why we are doing fair and effective disciplinary action. First, of course, we want to be fair to the employee, but then overall, for the organization as well. Okay, so we see the big picture. So whenever I do things also like this, I see the big picture. Okay, how does it benefit the organization? And in the end, it benefit HR as well. See, the positive side, benefit HR in the long run. Okay. Okay, so what's the role of HR? Got any questions? Yeah. Okay, got one question. I noticed that one of the employee consistently taking medical leave at least once a month or few days in a particular month. What other actions should be taken by the employer? Okay, taking medical leave, what you can, do you have a panel clinic for them to go? If you've assigned a panel clinic, meaning appointed by the company, then you can check their medical records if you have assigned. Yeah, have you? Okay, so if you don't have, what I've done in this case before is I will restrict them to certain medical clinic only. Let's say they are staying in Subang Jaya, okay? So I will pick one Subang Jaya clinic near their house, and then I'll pick one more clinic near the company or office. Then I will give a letter to the employee to say only these two clinics you can go. And then I will write letters to the clinic to inform that give us a report of the issues with this employee. What are the issues? Okay, that's one. Second thing, of course, you can send the employee for a full medical checkup to find out, okay, he's having problem. Okay, then later on, maybe he can seek treatment at a hospital. Maybe it's a real case, you don't know. Okay, so restricting clinics, one, getting the reports from the clinic, second, third, send them for medical checkup. Fourth, the most effective one, I would say, KPI. Okay, have a KPI for each employee. So even though they go 20 days medical leave, they must meet the KPI. So if they don't meet the KPI, then you can take action with poor performance. Then they will be reluctant to take the medical leave. Okay, so KPI, KPI, KPI. That is my favorite thing to do. Okay, Wong asking example of loitering. What do you mean by examples of loitering? Meaning they are not at their desk, could be, they are not working, or they are going to the other colleagues' desk, talking stories. That would be termed as loitering, not doing their work. Okay, so again, to address this, as I mentioned earlier, KPI. Sometimes you want to monitor the employee up to the minute is so difficult because they loiter, they come to work late, they lepak, they chit chat. So that's why I found the best solution is give KPI. You don't meet the KPI, meaning there's something wrong you're doing. You're not working 9 to 5 as required. Okay. Okay, another question by is medical certificate must be accepted from government clinic. You cannot reject. Cannot, sometimes, yeah, they will do that. I've seen. That's where they get the fake medical certificate last time. Because usually the syndicate who's selling fake medical certificate, they actually sell. Last time, many years ago, for 1 day medical leave, they have to pay 20 ringgit. So if they put 2 days there, pay 40 ringgit. So usually they will issue fake medical certificate for government clinic. For private, they don't do. They do for government. So, but government clinic, if they produce medical certificate, you must accept. Okay? But you can ask them, have a chat with them, ask them why you're not going to panel clinic. Why you want to go to government clinic. Have a chat with them. Get the details why. Right? Yeah. Easily, yeah. They want to get MC, they will go to uh, yeah, to government clinic. Sometimes they say stomach ache, headache, already get MC. Okay, so you can advise them, please go to the panel clinic because we are worried. You can say this way, you're worried about their health because they are constantly sick and we want to help you. We want to send you for full medical checkup and then we want to send you to our clinic where we can give you more uh, focus and treatment. Because if you go government clinic, we can't help you. Right? Migraine, migraine is the most valid. Migraine is difficult to check actually. Yeah. So when they go to a doctor, say migraine, actually I don't know how doctor can check. Doctor will just say, okay, right? So like stomach ache also difficult to check. Yeah. Diarrhea also, yeah, diarrhea also difficult to check. Doctor can't check really or not this problem, right? So if it's frequent, that's what the 3 steps I told you do that. Okay, restrict them, go for full medical checkup, and then issue KPI. Okay, that will address all these problems. KPI can be, I know most organizations do KPI is yearly, but for this kind of cases, you can even do monthly KPI or weekly. All right. I did that with one of the employee. Okay. One of the employee was a poor performer and then frequently going on emergency leave every time. Yeah. So I gave a KPI, but then I asked the employee to write daily. Okay. Daily in hourly, I gave her a template in Excel. Daily, every end of the day must send the report what she has done for the day to meet the KPI to me and her supervisor. So guess what happened after that? After 1 month. She couldn't perform. She couldn't meet the requirement. She herself resigned. Okay. So sometimes you have to be, this is one of the way to keep them on their toes. Keep them on track. Can we include medical leave taken as part of their KPIs? I wouldn't recommend that. Medical leave is actually one of the benefit given under the Employment Act. Okay. And you can't say, oh, you don't take medical leave. I wouldn't advise that. Because if they are really sick and they don't take, then they'll become worse or they will spread the disease to the employees in the office. I've seen that in my own staff last time, my HR staff, because that company I work for, they have an attendance allowance. If you don't take medical leave per month, you will get 100 ringgit. So this guy, he's sick, he'll come to work. And then productivity down because his fever, he can't really do the work. And then he might spread his fever or cough and cold to another colleague. So I wouldn't advise putting in KPI or even giving attendance allowance for medical leave. Because some are genuine cases, they force themselves to come. Okay. Yeah, 𝐂𝐟𝐼𝐵 says something like work done form. Yes. You can put the work done form on a daily basis, what they have done. But that employee I did from hour to hour, ask her to record. From 9 to 10, what did you do? 10 to 11, what did you do? Okay. Noor Sharini says, I have a question. Using an online doctor gives online doctor, how to give MC? The doctor haven't even checked her. Is it is the doctor certified under Ministry of Health or not? You need to check first. I don't think so. Yeah. If the MC must be valid from registered doctor under Ministry of Health. If yes, then can. But this one I don't think so. But is the clinic certified? How to give online MC? What kind of illness? Can you share what illness was it? She got the MC. Okay. This one we don't recognize as having MC here. No. Yeah. This one is they have to take their own annual leave. Unless you are in Japan. Japan do give for period pain, they give a medical leave, they recognize. But here Malaysia, we don't recognize yet. So it's not considered an illness. So if they want medical, they want to stay home, don't want to work, take annual leave. And then online doctor is not valid. Don't think so. How can he check? How does he know what illness? At least he has to, check the patient for something, right? Temperature or, heartbeat, spleen, whatever. So, and this one is not an illness, as I said. So you no need to accept. Okay. Let's go on. Role of HR. Okay. So HR role. So this is in a nutshell, yeah. So first you issue act of misconduct, either is implied or expressed. You take disciplinary action. Remember I said corrective, record it. Then if there's any update need to be done for policy, update. So this policy update is one of the preventive action. So that is clear for the employee, they don't go and do this misconduct again. Then you need to update management and brief employee. Yeah. So one more thing just now I mentioned, if you're doing putting an employee handbook or policy, it's not enough just to print the policy and distribute or put it online. It's not enough. So what I used to do is, once I update any policy or even roll out a policy in any organization, I will have a briefing session face-to-face. Now you can do Zoom as well, right? So I used to bring in all the employee by batches, by department for briefing session on employee handbook. So it's very clear for them, okay, this is what is in the handbook. Don't tell me you don't know. After briefing, sign, acknowledge receipt of the employee handbook, acknowledge understanding. Don't understand, please ask question now. So later on, I don't want you to say, hey, I don't know what you wrote in English, I don't understand. You wrote in Malay, I don't understand. There's no way they can do that. Because I do hold a briefing session. And any new employee comes in, as part of the orientation session is briefing of the employee handbook. And then they need to acknowledge, receipt, and sign, and then we file it in their personal file. Okay. So is it only HR when it comes to misconduct? So everyone will look at HR. HR's role is actually assisting the various supervisors and managers and the organization as a whole to ensure disciplinary process is followed as per the policy and as per the various acts or law. We are there to give the guideline and make sure the company complies. So a lot of people misunderstand HR taking action against me, HR, I'm scared of HR did this, did that, did that. Yeah, they forget that HR is actually helping the supervisor manager to ensure everything is compliant. Okay, so of course HR get involved, supervisor manager need to get involved as well. They cannot say, I don't know, you handle. Right? So I always get them to supervisor manager, get them involved. And I have a separate briefing session for them on how to handle employees. Yeah, otherwise they make mistakes. Employee also can file a complaint at the labor department or IR department. Supervisor manager has the authority. Yeah. Okay. There was one manager I had in my previous company. He says some employee, he said very difficult, and doesn't want to follow his orders. So he will call them in, and then he will show the door, the exit door to the office. He will say, if you don't like to work here, the door is there. So one day he told me he does this. Okay. So I stopped him at his track. I said, this is the last time you're going to mention the door is there. Because that would construe as constructive dismissal. And you as a manager, if you say that, you have the authority. So the employee said he wants to terminate me. Okay? So even the word, the door is there, also don't say. But other companies I've seen more serious, they have just given a resignation letter, they prepare and then give to the employee, ask them to sign, which is also wrong. But this one is subtle, but still is wrong. Okay, that's why HR involves supervisor manager in the disciplinary process also. Okay, they need to know that they have the authority as well. Okay. Then we talk about maintaining professionalism. So when disciplining employees, some of it we talked about earlier, so some may be repeating. So prepare thoroughly, prepare all the information that you're going to give the employee, what they have done wrong, what went wrong, what clauses they didn't follow. Choose an appropriate setting. Just now I mentioned, go to a room, make sure that nobody knows that they are called into the room as well. Okay, because sometimes some people know, if possible, they don't know. Okay, remain calm and composed. Use clear and neutral language. If they don't understand English, talk to them in Malay. Either Malay or English acceptable. Other language, I wouldn't advise. Okay. Why? Because employees should know lah. Unless it's a foreign worker, then you may need a translator. Right? And listen actively. Listen to them first. So we talked about consistency and fairness. So ensure there's fair and just disciplinary process, clear rules and regulations, systematic disciplinary process, establish database of cases. What do I mean by that? So let's say 2 years ago, there's one employee who come in to work late 4 times, and then you issued a warning letter. Okay, that was 2 years ago, yeah. And now another employee comes to work 4 times late, and then you just give reminder letter. So it's not consistent, yeah. 2 years ago you did that, 2 years later you just give reminder. So why? Need to give a reason why. Otherwise, that's why I put here, establish database of cases. I used to have an Excel sheet of all the cases for many years, right? So that I know, okay, these cases, let's say have, these are the cases, these are the action taken, so that we are consistent throughout. Unless our policy change, then give a reason to the employee as well. Because if not, employee say, hey, last time, my friend, you did give a reminder only, but now why so severe warning for me? Okay. And then have an appeal process, which I've already said. Principle of natural justice. Let's go and find out what does it mean. Principles of natural justice. Okay. The rules of natural justice, also known as principle of procedural fairness, are fundamental legal principles to ensure fairness and protect the rights of individuals. Yeah. So they encompass the following here. The other side, decision maker should be independent and unbiased. Decision should be based solely on evidence and arguments presented during proceedings. If there's a DI, right to a fair hearing and give clear reasons for the decision. So once decision given, also tell why are we deciding this. Okay, the severity of their misconduct. Explain to them. Next, avoid biases and discrimination. So it's essential again for fairness and maintaining a respectful workplace. So here are a few 10, I put here, 10 things. Adhere to established policies, base decision on concrete evidence, involve multiple perspectives, look at few sides of the story, equal treatment, beware of unconscious bias. What does it mean? 5. Unconscious bias. So sometimes the employee, let's say, the employee is always very quiet, follow all the rules. I had one employee like that. So, and then you think that, oh, this employee is very good, very polite. Okay. Then when it comes to misconduct, you may say, hey, this employee is a good employee. So you are biased. And then maybe your the misconduct, the consequences, the letters that you give, maybe you say, reminder enough lah, because he's a good employee. All the time has been good. So this is what we call by unconscious bias, right? So it could be in terms of race as well. So sometimes it has happened. If let's say the manager and the employee of the same race, they say, yeah, close one eye lah, don't do anything lah to this employee, kasihan dia. Okay, it could happen. So this one you need to beware. That's why I said have a database of cases so that you don't fall into this trap. So ensure fairness, use structured evaluation criteria. You can have an evaluation form on how you do the investigation. Okay, what are the criteria you look for? Monitor and review policies. Policies maybe sometimes you need to review. Seek external advice if you need to. If you are a member of MEF, Malaysian Employers Federation, you can seek their advice. They have IR lawyers that can advise you. So previously in my previous organization many years ago, we were part of MEF, we were a member. So I have called them a few times. So most of the time I just pick up the call, the consultant or legal advisor available, quickly they give me an answer. Okay. So sometimes I've even drafted letters and sent to them. I say, please review my warning letter or my show cause letter. You think it meets all the criteria or not? Okay. Or even the termination letter I give to them. Please respond. Please verify. Yeah. So if you're in doubt, best to verify and best to get legal advice from IR lawyers. Okay. Ideally, it's an IR lawyer lah. Of course, some experienced HR also is able to help. But if you are a member, as I said, then you can get advice from IR lawyers. And foster an inclusive culture. So earlier I mentioned about culture as well. Yeah? Right. Okay. So we go to training, next part. So training is the one I mentioned earlier that get supervisors and managers involved train them as well. So you are here today, good, attending this session. So if you are not HR, it's also good that you're attending. So this kind of training, disciplinary action, I would advise for supervisors and managers who have subordinates. Those who manage people, they must know all these things and more. Okay, as I mentioned, just now the manager say the door is there to avoid all these problems from happening. Okay. So here I've given some of the reasons. So the supervisor management is the first contact person with the employee, right? He's the one who's seeing them almost every day and talking to them, giving feedback, whatever, and doing the performance appraisal. So that's why they need to be trained. And they need to know what are the do's and don'ts and what are the acts involved, what can we do, what cannot do, right? And you see the last one, D, yeah? So ensure employees are briefed about innovation and changes before they occur so that they can explain management policies and intentions to the work group. What I mean this is, when there's a change in policy, let's say talking about employee, anything related to employee, you're going to change the policy. Let's say now you said, okay, come to work. Last time my company, you said 15 minutes late for work, we don't consider as misconduct. We give leeway 15 minutes. So after 15 minutes, you come late, then it's considered a misconduct. We will issue you a reminder of warning. All right. So this one, maybe later you want to change the policy. Okay, change now. Say immediately you come 1 minute late, also you are liable for a warning. Okay. You change this policy. What I mean by D is brief the supervisor manager first. Before even goes out, blast it out to all employees, brief them first. Okay, these are the changes, know first. Then when they blast it out, okay, when the employee comes and asks the manager or supervisor, they know, yes, this is the new. If not, they also like blur, everyone blur. Only HR and MD or CEO knows. That is not good. Okay, what I mean is, so it's best to brief them first. Okay. The first part I talked about preventive and corrective. So I always look at preventive first, more emphasis, so that the corrective is lessened. Yeah, that's what I used to do. One company, I was both. I was the IR and I was the ER, employee relations. So these are the jobs for employee relations. Employee relations, creating harmony at the workplace, industrial harmony, so that there is less misconduct at the workplace. Yeah, so I was handling both. So these are the preventive. So here we won't talk about details on this because we won't have time. So these are some of the things like orientation, you have a grievance procedure, you have stay interviews, exit interview. Exit interview is when someone resigns, you find out, hey, why did you resign? What happened? You know, you can have a set of questions to give them. Then you can improve the situation from there on. Stay interviews would be the opposite. Those who are already in your organization, not resigning, also go and ask them, hey, why you're still here? What's the thing that make you still want to work here? Is it your manager is good? Is the benefits good? Ask them, why are they here? Not just when they are leaving. When they are staying, also ask. Then you know that you've done a lot of things right. That's why they're staying. Or sometimes they may find out, yeah, that one is no good. Can we have something else? Maybe the allowance is not enough, for example, yeah. So then you also get some feedback from them. You can improve before they resign. Okay. Improve the hiring process so that you don't attract all those people who will commit misconduct. Okay. Have learning and development or training and development for the employees so that they are upskilled. when someone is upskills, if you see, there'll be less misconduct for those who are upskills because they are concentrating on their career, their future, and so on. And last one, communicate expectations, right? So like just now, there was a question where there's no JD, a task was given. So communicate expectation. When the employee manager gives a task to the employee, tell them, this is what I want you to do, 1, 2, 3, 4, 5. And I want you to finish by 4 p.m. today. I want you to come and see me and tell me what you have done. And if you have any questions, please let me know as well. Okay? Expectations. Some managers I've seen, I've talked to a few, they don't give clear information and what is their expectation. Then the employee all have to guess. Does boss want this? Was it this one? Some afraid to ask because the boss seems so garang. Okay. Right. Any more questions before we go into the case studies? Few cases I to share with you. Okay, no questions yet. So let's go on to the case. Okay, first case is on sexual harassment, right? So of course, the case when it goes to court is public knowledge. That's why there's a name and company name already. Okay, that's why I said every time try to avoid going to the court. So before I talk about this, there was one time I went for an event and I met one of the company director. He was the owner, right? So I was talking about what I do, all the misconduct cases. Then what he told me, he said, I can pay them off. It's okay. Let them go to court. Never mind. I got money. I'll just pay them off. Okay. So to that, what I said is, I know you have the money. You can pay them off. But one thing I want you to remember, I told him, is your reputation. Reputation of the company. Because if your employee keep going to court, to take you to court, there's something wrong with your organization, right? They may be wrong, they may lose the case or win the case, never mind. But there's something wrong in your organization for them to reach that level. Then it doesn't show your organization in a good light. It spoils your reputation, I told him, right? Then he kept quiet. Then he understood, okay? So sometimes it's not just the money, it's the reputation, yeah? Because your name will be published already. So if I were the HR, I want to join a company, most of them, as I see, is big companies, MNCs a lot, get into this kind of trouble. So if I see a lot of cases coming there, if I, the HR, want to join, I say I don't want to join. Because there's a lot of things going wrong in that company. That's why the employee can easily take a case against them, right? So this case, let's come back to this, sexual harassment. This case is Loganathan versus Murphy Oil Sarawak. What happened is Loganathan was accused of harassing another employee in the company, okay? So he was given a show cause letter and then he was, a DI was done. They did follow the process, excuse me. They did follow the correct process. Domestic inquiry was done, okay? And then they dismissed him. So terminated according to section 81C. You see here below, Employment Act. So that after he was terminated, he took them to court, industrial court, and say that the dismissal was not justified. Okay, it was no just cause for dismissal, and then the judge court favored Loganathan. So I put in why here already. You see here. Okay, DI was deemed invalid. Case was dismissed because the victim's name was not there. So it seems the HR want to protect the employee lah. Okay. When they issued the show cause letter to the Logan Adharan, they put there, you've done this, done that, done that. But there's no name. Who did you do it to? Remember when I said issue the letter, you must have who, when, what, how happened. So here the who was missing. It's very silly. So if you don't have a who, your DI also is deemed invalid already. Because the witness also didn't come to the DI to tell that he harassed her. So the case was dismissed. Right? So my question to you, what could HR or management have done differently in that scenario? Because the employee, I think, didn't want to come forward and don't want to be reviewed and don't want to come to the DI. So what can HR management do? What do you think? CCTV footage. If there's a CCTV lah, right? Sometimes in the employee, some offices or manager's office, you won't have a CCTV, right? So what can we do? Anyone? Or incident report, write and signed by the victim. Okay. Still invalid, yeah? If she doesn't want to come to the domestic inquiry, invalid. So what I would do, I was the HR, I would throw out the case. I wouldn't even do DI. I said, you want to complain, you must tell your name, and then we do a domestic inquiry, you must be there to tell what he has done. Exactly what he has done, you must put point by point form and then details. You simply can't accuse someone and then run away and hide. Cannot. Even though you're the victim, can't do that. Okay, similar case happened in my previous company. Again, a lot of cases happened because I was working for many years. So this employee, we had an annual trip. Yeah, we went to another state in Malaysia. We had an annual trip. So after the annual dinner, we had an annual dinner. After the annual dinner, some of them went partying at a nearby bar. Okay, I was there also, but I didn't go to the bar. I went to the room to sleep. So I don't know what happened. So they were at the bar, and then this lady, she got drunk, our employee. She had too much to drink, and then she collapsed on the floor. So two other male employees held her up and took her to the hotel room. Okay. So the next day, nothing, no news. I don't know anything about it. After we come to the back to the office, she started complaining. But she didn't come to me. I was the HR. She didn't come. She went and complained to so many other people that these two guys, one was a manager, one was an executive. Okay, she said the two guys molested her. So after that, I say, you are talking around everywhere, you're talking. You didn't come to HR. Now I'm calling you in, file a lodge complaint, and then I will take up the matter. I will issue show cause letter to them and do a DI. I told her, you must lodge a formal complaint with HR. And then guess what? She didn't want to. But she went around gossiping to so many people, which is no good. All right? We don't know which is true or not. So I said, you have to stop talking about this. If you don't want to lodge a formal complaint, I don't want to hear you talking about it anymore. Right? Unless you formal complaint, then we'll do something. She didn't want to complain. So I told my MD, which is my boss, I said, this is what happened. She doesn't want to complain. I'm closing this case. That's it. Cannot do anything. I won't even question the two people. No. Right? So what they did was wrong. Yeah, they shouldn't be doing that. And guess what? Why the lady didn't want to complain? The employee in my company, yeah? She was the daughter of a judge. It was one of the court judge, and she was the daughter. Okay. So sometimes they want to hide, they don't want to say anything. So sorry lah. We do the part. The court threw out the case because no name. Okay. Wong is asking, what's the difference between implied or express? Implied and express means you're talking. Implied means you're doing some action showing that what you want to do, what you want them to do. Implied is through action. Express is through talking, right? Okay, next case. We have 4 cases. We only have about 9 minutes left, so I'll go a bit fast. So this is excessive and abuse of medical leave. Just now we talked about it. A few of you had questions. So same thing happened. This one is Klang Port Management versus 𝐂𝐟𝐼𝐫. Look at the amount of MC he's taken. Again, if I was the HR there, I wouldn't allow so many MCs by one person until it becomes so dire. He has to go to court to complain, to terminate him. Okay? They waited until so many, 4 years he's been doing this. Okay? So they sent him for a medical checkup, and then the doctor certified him to be fit for work. But then he continued to take medical leave. After that, he was dismissed. The court went to court. Court says, medical report says he's fit to work. He simply took a lot of medical leave, so it's justified to dismiss him. Okay. Next case, I'll go fast, yeah. So what could HR management have done differently? Just now I gave you a few pointers, right? What to do before they even reach 47, 50 days medical leave, time to do something. I will monitor last time. Everyone I will monitor who are the person exceeding 10, already go and talk to them already. Exceeding 10 per year. Go and have a chat with them already. Don't wait until they take 20, 30, 40. Right? Next case. This is on performance improvement plan. I think you all are aware what is PIP, right? Okay. So I want to highlight this case because some companies make the mistake of dismissing an employee after PIP. Remember, when you want to dismiss, it's after DI, not PIP. Okay? So this company, Schneider Electric, dismissed Tan Chi Tiam. He was a manager. For poor performance, they give him PIP, give him some time to improve. At the end of the PIP, they say he didn't improve and dismiss. Yeah? So court says he must be given lesser punishment because it's performance issue, not misconduct. Remember, termination is only for misconduct. Poor performance is not misconduct. It's a performance issue. Right? So here, he was reinstated. That's the worst part. Go back to work and perform poorly again. And then he was awarded 107,000 ringgit. Okay. Right. Another question, 𝐂𝐟𝐼𝐴. To check an employer has 14 days MC for the second case study. Does this 14 days was included? I think it's included. Yeah. 14 days is included, this one. Of course, all these I'm giving the case. You can also go and look at the case in full. As you all know, in the industrial court case, there will be a lot of information on the award. Here, I only put the summary. Okay, so that's why I'm giving you the company name and name. You go to the industrial court website, key in these names, and then the full case will come up. So for your knowledge, you can go and have a look at the full case, right? 14 days, yeah, it's also calculated. Yeah, as I mentioned, even above 10, I already go and have a chat with the employee. Even though 14 given, yes, but already 10, I say something wrong somewhere. This employee either really sick through and then we need to help the employee, or is taking advantage. Okay. So this is PIP. Next time PIP, don't dismiss, right? And then the last one is drug use. MIC Berhad versus Zulkifli. Okay. The employee was hired as a caterer, and then they did a spot check to check his urine, and then they found that he has drug, and then immediately dismissed. Then he took the matter to court. So the court asked all these questions, and they confirmed yes, he was against the company policy. Employee was aware because the offer letter itself states that he will be subject to spot check, already stated. Okay, and it's a serious misconduct. So dismissal was with just cause and excuse. So can be dismissed. So as I mentioned, it must be clear, either in your offer letter or policy. This was very clear by MIC. MIC was very clear, and then they dismissed it. This was in 2010, yeah. So they had a drug and alcohol policy, was clear. Okay. So court found dismissal was with just cause and excuse. Okay, Wong is asking, can employer do something if employer not given return of PIP even reminder given? What do you mean by that? PIP didn't give, reminder also not given. So now time to give, if the employee is at fault or not performing, time to give now PIP or reminder. Is that what you're asking? PIP session minutes. Yeah, must be written. Performance improvement plan must be written letter given to the employee to say that, these are the things that you need to improve upon. Maybe you're given 6 months. Ideally, give them 6 months, or 3 months, could be 3 months and extended another 3 months also can. Right? Drug and alcohol policy place, does the company required to conduct the DI before proceeding? For this case, they didn't do. Okay. The company issued him his termination letter. Example, I mean, this was a clear case lah. They already have evidence. That's why they immediately terminate. The evidence is in the urine test lah. Right? What lesser punishment should be given cannot dismiss. After PIP, I would say PIP, after PIP, actually no punishment. It should be more on training. Give them a training, coaching, or guide them step by step how to improve. And then like there's now one employee I did, ask them to write down daily what they're doing. You can do that as well. Say we want to help you, daily or hourly record what you're doing so that we can improve your performance. Right? So what other questions? Let me see. A few more questions that are coming. What is the best method to terminate the poor and non-performing employee after given the PIP and training? So as I mentioned, ideally don't terminate lah. I mean, termination is for this misconduct. So ideally, you're not going to terminate them. Give them more stringent KPI. Yeah, the daily, hourly KPI, that will work. Most of them, if they really want to improve, they will work on it and improve. If they cannot, they simply cannot meet the KPI already. Right? If they don't meet the KPI, then the next action what you can take is, you can say you're not fit for this job, you cannot perform, so we're going to transfer you maybe to some other department or some other position. Then we are going to train you in that position and then give you a chance to perform there. Like my case, we had one employee, but we had 8 locations, throughout Malaysia. So there was one poor performer in Ipoh. We said, you're performing poorly, we want to transfer you to Johor. Because only vacancy for the position which we think that you can do the job is in Johor. So something like that you can do, right? And last Wong says, in the written notes written, employee, employer both can keep, but employer don't have employee after the session. What do you mean by that? Huh? The last written notes. Employer don't have employee. What do you mean by it? Doesn't give? You mean a written verbal reminder, is it? If verbal reminder or verbal warning, then normally it's just a form to be kept by HR. So employee won't get the form because it's not a written letter to them. Okay, employee can write themselves. This form is for a company format. So employee can write their own notes. Poor performer, ideally don't demote, as I said. Don't demote. Yeah, it can lead to constructive dismissal, yes. So don't demote. As I mentioned, give them more training, more stringent KPI, or change their job scope. Change to a different job scope, but no demotion, same salary. It's very tricky, this one. Same salary, and what other things you can do is, upon year end, appraisal time, you say no increment, no promotion, no bonus. That one you can do. Poor performer, you got no bonus, no increment. Stay like that until you improve. Okay? So we've come to the last part, summary. So managing discipline and misconduct should be ideally handled by HR together with immediate supervisor and manager. And remember the principles of natural justice. Prevention is better than cure. Remember, preventive action, corrective action. Before taking disciplinary action, think of the consequences first. Remember, positive and negative consequences. So always strive to get a positive consequence. Okay, that's all for today. We've completed our session, and this is for you to reflect. So luggage, what new knowledge will you take with you today? How will you use it? So if you gain some new knowledge, you need to implement and use it, of course. Knowledge is there to be used, right? Not to be just kept. And then guess, look at guess. What resources or any other support do you need? You may need some. So reach out to Excel Academy. We have other trainings as well. See where you can attend them. And then exhaust, last one. What are you leaving behind? Whatever practices that you've done, maybe it's in not complying the acts or not effective or not fair, you need to leave it behind. Need to think about it, reflect on all this, all right? Okay, there's a note here. The video recording will be available on YouTube. So the YouTube, you can watch this whole session again, all right? Okay, that concludes our session for today. Any last Q&A? Thank you for attending this session today. It's been nice having all of you. Most of you are quite interactive, asking a lot of questions. That's what I like, so that, we learn together. And then I hope to see you all in my next sessions, right? So in the meantime, have a good day and bye. There's no other questions. You're welcome. So I hand over to Excel Academy.
All right. All right. Thank you, Miss Carol, for the excellent presentation just
All
now.
right, welcome.
Okay. Regarding your certificates, we are pleased to inform you that your attendance has been recorded and your course status will be marked as completed after the session. You will receive your e-certificate through the NTW portal upon successful completion of the TEE assessment. The certificate can be generated from the applied course section of your individual profile. For those who are registered through the Google form, we are sorry to inform you that there is no certificate will be given. As for the video recording of this session, it will be available on our YouTube channel at 𝐓𝐫𝐚𝐢𝐧𝐢 Academy Malaysia by tomorrow. Alright, we don't have public training for HR, but if you are interested more, we can conduct in-house training for you guys. So for the public course, we are more focused on IT and digital marketing courses. Now, let me inform you about our upcoming training sessions. If you are interested in enrolling in one of these courses, please contact us. We have Microsoft Excel basic level, Microsoft Excel intermediate and advanced level. We have Microsoft Power BI data analysis and dashboard reporting, Microsoft Power Query data cleansing and processing, ChatGPT and AI tools, content creation and marketing, Canva design bootcamp, digital marketing masterclass, digital marketing professional, SEO and SEM, social media marketing. All right. Thank you all for your participation and have a great day. Once again, thank you, Miss Carol.
Okay, you're welcome. Thank you. Bye, everyone.